prepared to have a charge conference. Is that correct? But you may have other matters you want to raise first. We, I believe, reserved early on your motion so we can address that. But I understand you also wish to accomplish a charge conference today, obviously subject to any rulings on motions. Let's go ahead and address the matter that we reserved on earlier. Ms. Duncan.
Yes, Judge. Earlier I addressed the defense's motion for judgment of acquittal, and once again I would renew all motions filed in this case, specifically the motion to suppress the defendant's statement to law enforcement and motions in limine related to that. Judge, there's no doubt the guilt of the defendant in the commission of the homicide is undisputed in this case. At this point, the defense has presented evidence to raise a reasonable doubt as to the sanity at the time of the offense, based upon Ms. Schenecker suffering from psychosis as a result of her mental health disorder. The state then presented rebuttal evidence which in no way has disputed that Ms. Schenecker was in fact suffering from a serious mental health disorder. Once the defense of insanity is presented by evidence sufficient to create reasonable doubt in the mind of the jurors as to sanity, the state then has the burden to prove sanity beyond every reasonable doubt. And if the state fails to prove sanity beyond a reasonable doubt, then the defense would be entitled to judgment of acquittal. It is my position at this time the state has not proven sanity beyond to the exclusion of every reasonable doubt. They've heard from a total of 6 doctors between the defense case and the state's rebuttal over the last few days. And not one of those doctors disputed in any way that, as I said, Ms. Schenecker was suffering from serious mental illness. You first heard from Dr. Solomon, who stated that the defendant, Ms. Schenecker, was suffering from bipolar with psychotic features, which was causing her to have delusional thinking. She did make some mention as to what those delusional thoughts would be. Specifically, the thoughts about Bo being molested, that Ms. Schenecker was having a brain tumor causing her to think that that's what was making her have the mental health illness. I'm going to talk about the 2 strange thoughts about pregnancy. And Dr. Solomon also testified that Ms. Schenecker was suffering from disorganized thoughts. It was her opinion that one would have to be very mentally ill to break the bond between the mother and child and then go ahead and kill them. But the biomechanics, I believe she stated, would have to override the DNA. However, she did state that the defendant had the psychotic belief that she was saving her children. And even during her interview with law enforcement, she was not in touch with reality because she wasn't convinced at that point that the children were dead when she was asking, are my children coming in later? When questioned by the state of Florida, Dr. Solomon never wavered in her opinion that sane people do not, in fact, kill their children. We then heard from Dr. Mayer, who talked about Ms. Schenecker's diagnosis of bipolar disorder with psychotic features, that she was someone who was hard to manage on medication, but also someone that had periods of good functioning. However, he did opine that after Winmore, the rehab facility, she was severely disabled, psychologically bad, and her grasp on reality was deteriorating. He was firm that it was not unusual for someone to look fine while falling apart. He also stated that buying a gun doesn't tell a lot about what's on a person's mind, especially when this is combined with the undisputed evidence that Ms. Schenecker was in fact planning on suicide with a gun. Dr. Mayer opined that the defendant knew what she was doing, but not that it was wrong. He too opined that she believed that she was protecting her children. He stated that alcohol alone cannot describe her action. During his cross-examination, he testified that Ms. Schenecker did understand society would think it was wrong to kill herself and kill her children, but that my position is this doesn't prove sanity beyond a reasonable doubt because Dr. Mayer then opined that it was Ms. Schenecker's state of mind that if people could understand her, that they would agree she had no way of communicating her point of view to them.
On the issue of insanity, whose burden is it? What is the standard again, Counselor?
Judge, the burden is that the defense has to raise by clear and convincing evidence that would cause a reasonable doubt as to the sanity of the defendant. The burden then shifts back to the state of Florida, who has to prove beyond a reasonable doubt that the defendant was sane before the case can go to the jury.
Go ahead.
Dr. Miller further testified that the defendant was having psychotic delusions and that she had no clear notion of right and wrong and was severely out of touch with reality. He never wavered from his opinion of insanity, and he stated that this doesn't affirm that Ms. Schenecker is not insane. We then heard from Dr. Myers, who testified that Ms. Schenecker had a severe mental health disorder, which was worsening as time passed. He opined that she was out of touch with reality and suffering from disordered thinking and paranoia. He stated that she fell in the 10 to 20% of bipolar patients that were hard to keep stable. He explained that people are able to do routine tasks while psychotic. Psychotic symptoms can't always be seen visually. Ms. Schenecker began a rapid downward spiral in approximately June or July of 2010, right around the time that the Abilify had stopped. And her condition had never improved post-rehab. Dr. Myers opined that the defendant was insane at the time. She didn't know right from wrong because she was suffering from delusional beliefs that she was saving her children. Today we heard from the doctors, the experts from the state of Florida. None of those doctors had disputed that Ms. Schenecker had a mental illness. It was my position that the evidence presented does not prove beyond a reasonable doubt that Ms. Schenecker was sane at the time of the event. We heard the opinion of Dr. Otto that the defendant was sane at the time of the offense, and he supported that this was testified by data. The data that he was referring to was the statements of the defendant. And in his words, these were the words of a woman that he referred to as severely mentally ill. And the same statements that he relied upon to make his opinion, he admitted were subject to interpretation. And then we heard from Dr. Stein on an issue similar to that those statements alone should not be used as the sole basis of an opinion. Dr. Otto stated that she had a clear thought to kill herself. She didn't tell the store owner, but this could be viewed as one believing that it's wrong to commit suicide, and that would explain this behavior. There's not evidence beyond a reasonable doubt that Ms. Schenecker knew the wrongfulness of her act. Dr. Otto placed much emphasis on Ms. Schenecker knowing the wrongfulness because she said things like, I feel horrible, this is the worst thing I've ever done. But he was candid during cross-examination that insane people can in fact feel bad about things that they've done after the fact. And finally, Dr. Otto couldn't say with any level of certainty that the defendant knew the wrongfulness of her act. We then heard from Dr. Taylor, who stated that the defendant was having a major depressive episode. He ruled out psychosis, but admitted on cross-examination to 2 psychotic episodes. And his diagnosis appears to be contradictory to all the other evidence that's been presented thus far in regards to Ms. Schenecker's mental health condition. Dr. Taylor stated that he gave great weight to the journal written by Ms. Schenecker to show that she knew what she was doing and that was wrong. However, he did admit that there was some confusion as to whether she knew that the children were alive or dead. And he referenced the same statements that I've already referenced to Your Honor. And this basically showed the fact that she didn't know the consequences of her actions, didn't know if the children were alive or not alive when she was speaking to law enforcement. Dr. Taylor explained that you can know what you're doing and intend its consequences, yet because you're insane, not know that you're doing anything wrong. And I conclude that his opinion did not prove that the defendant was sane beyond a reasonable doubt. And finally, we heard from Dr. Stein, who opined that the defendant was sane at the time of the offense. She agreed that Ms. Schenecker was suffering from bipolar, and that persons with psychotic features, they're not always, she stated that persons with psychotic features are not always out of touch with reality. Her opinion to the court was that the defendant was not psychotic and knew what she was doing, along with the wrongfulness of the acts. However, many of the things that she referred to were things after the fact. And again, as I stated earlier, the other doctors who testify that one can be insane and feel badly about things after the fact. And she did agree that Ms. Schenecker was tangential and that diagnosis of psychotic features was made at a time before USF. She was severely mentally ill, deteriorating, and confronted with stressors, which were enhanced by the substance abuse within the 2011 time frame. If I can have just a minute, that's as far as I got to organize before the break. So, Judge, the defense's position that at this time the state hasn't presented evidence beyond a reasonable doubt that the defendant was sane at the time of the offense, and we would ask for a judgment of acquittal by reason of insanity. I would also rely upon my earlier made argument for a motion of judgment of acquittal. This time I would just like to add to the argument that I previously made in regards to premeditation. The evidence that we've heard now from the doctors would go towards the defendant's ability to form the premeditated thought. Specifically, as testified to by Dr. Otto, what's going on in the mind is definitely affected by mental illness. So that's all I have.
Thank you, Ms. Jenkins.
Thank you.
State.
The state would agree that we have not rebutted evidence that the defendant was mentally ill at the time of the offense. However, that's not the end of the inquiry. The state has, through the presentation of 3 expert witnesses, adequately rebutted the defense of the defendant's inability to know right from wrong at the time of the offense, the nature of consequences or the wrongfulness of her conduct. And as such, I suggest to Your Honor that it is not a jury question and that respectfully the defendant's motion for renewed judgment of acquittal should be denied.
Anything you wish to add, counsel?
No, sir. Thank you.
Right. Thank you. I've presided over this trial. Listened carefully to the argument of counsel at this stage of the proceedings. To the extent counsel for the defense has renewed all prior objections and motions, including the motion to suppress, motions in limine, related motions in limine, and other motions in limine, make it clear that the prior rulings stand. To the extent this is a renewed motion for judgment of acquittal at this stage of the proceedings, court, having listened to the argument of counsel and considering the evidence of record, finds that there's competent, substantial evidence for this to go forward. This is for the jury to decide. Accordingly, the motion for judgment of acquittal as to count 1 is denied and as to count 2 is denied. Okay, thank you. Now, do I understand, counsel, at this stage that you're prepared to address the instructions?
Yes.
Yes, sir. There are 2 instructions I'd like, revisions to instructions I'd like to hand forward to. They've been provided to the defense counsel. One is the manslaughter instruction, that's to count 2 of the indictment, reference Kaylee Schenecker. There was a correction in enumerated paragraph number 2 to comport to make consistent the name Kaylee Schenecker throughout the
Essentially corrected the first paragraph to reflect appropriately count 2, correct?
Not only that, Judge, but we also call it that in enumerated paragraph number 2, it referenced Bo Schenecker rather than Kaylee Schenecker, so that
I
was
see.
changed.
Okay, good. Thank you.
And I believe this is on the second page of instruction 3.9, where we have redacted from the instruction any reference to the defendant having become a witness in trial.
Right. 3.9 carries as part of its standard language a recognition of instruction that's necessary when a defendant testifies. In this case, the defendant did not testify. Accordingly, that needed to be taken out. It appears you've accomplished that. And of course, we will then appropriately include 3.9A. Is that what you understand as well, Coach?
Yes, sir.
Yes, sir.
Okay. Now, let's, in an abundance of caution that ultimately what we're going to do is we're going to go top to bottom through these instructions, at which time counsel are going to have an opportunity to indicate whether they have objection or no objection or make comments, recommendations. This will be for everything from the substantive comment of the instructions to the very order of presentation, to format, to spelling, to any and everything else to make sure that they are correct in the law and also not confusing and appropriate presentation to the jury. So we're going to go top to bottom. Now, before we do that, I want to make sure, counsel, each of you have, in the same order that I have, a mirror copy of these instructions in front of you, correct?
Yes, sir.
Yes.
Okay. And you've already worked on them. I know you've talked and gone over them together. That's correct as well?
Yes, sir.
Yes, sir.
All right. First thing I'll do is before we begin that top to bottom review, I'm going to ask, are there any special instructions or major points of contention in the instructions that we need to address?
There are no special instructions other than the insanity instruction, which is already in the package.
Well, that's actually a standard instruction, but I'm asking if there are any special instructions or other instructions. So, for example, earlier the state had mentioned its intention to ask for an instruction that I believe it actually wanted during the course of trial, proposed that limiting instruction dealing with that videotape and the appearance of the defendant on January 28th. I take it that no longer is the request of the state.
I fell asleep at the wheel, Judge. It should have been requested at contemporaneous with the publication. I did not do so, so it's untimely at this time.
All right, I just want to make sure, since you had handed it to me, that we addressed it and it wasn't left as a question mark in the record.
It is not, and I am not requesting that as a special instruction to go back to the jury at this time.
Okay, other special instructions?
No, sir.
No, sir.
Now, any major points of contention on the packet that we all have in front of us right now?
Not from the city.
No, from the defense.
All right, well, then if you're ready, we're going to go top to bottom. Now, since I send all instructions back, and by the way, let me make clear, the jurors will each have a copy of the instructions. Each have a copy of the instructions. There'll be an original packet that goes back that'll be for the foreperson. That will have the marked original, the verdict form. Each of the other jurors will have a copy. It'll be marked copy to include a full package, so they may all have them in front of them to consider as they go about their deliberations. With that announcement, we can start at the top, and I'll simply hear from you as to each instruction. And again, this includes order of presentation, any and all matters. And again, since I'm sending back all instructions, including those already given, consider that, okay, as we go through. First, the qualifications instruction. This is where you say no objection if you have no objection.
No objection.
1.1 introduction.
No objection.
No objection.
1.6 note taking.
No
No
objection.
objection.
2.1 preliminary instructions.
No
No
objection.
objection.
3.6 C, the insanity psychotropic medication instruction that was given.
No objection.
2.2 instruction to edited recording that was given.
No objection.
2.6 use of transcripts of recordings that was given.
No
No
objection.
objection.
2.7 closing argument.
No objection.
No objection.
3.1 introduction to final instructions.
No objection.
3.2 statement of charge.
No objection.
3.4, lesser included crimes or attempts.
No objection.
No objection.
7.1, introduction to homicide.
No objection.
No objection.
7.2, murder first degree as to count 1.
No objection.
No objection.
7.2, murder first degree as to count 2.
No objection.
No objection.
7.4, murder second degree lesser as to count 1.
No
No
objection.
objection, but I do need to bring a hyper-technical correction that we had made to this. As previously presented as to enumerated paragraph number 2 of the bottom portion.
Okay.
After the word spite in the original packet, there was not a comma. Ms. Duncan caught the fact that the standard instruction as published by the Supreme Court of Florida has a comma. I don't think that's appropriate, but we concorded it with the standard instructions. But I'm saying it's hyper-technical.
No, I appreciate you bringing that to our attention. I don't think there's anything that's, quote, hyper-technical, as we've seen so many times with otherwise approved instructions.
Well, we've seen a comma require reverses.
Yeah. So I take it, I see exactly what you're talking about. I take it both parties looking at this believe that it does not detract from the meaning, alter it in any way, shape, or form, or confused by having the comma there, does it?
I agree.
Agreed.
All right. So, again, 7.4, murder second degree, lesser as to count 1 is acceptable.
Yes, sir.
Yes, sir.
7.4, murder second degree, lesser as to count 2.
Yes, sir, and the same correction was made as to that one.
Okay. Any objections?
Yes, sir.
7.7, manslaughter, lesser as to count 1.
No objection.
No objection.
And I appreciate you got the latest version of that, and it appears you've done that correctly. I think the earlier submission, for lack of a better term, was the outdated version. 7.7, manslaughter, lesser as to count 2.
No objection.
No objection.
3.3D, possession of a firearm and discharge causing death. This is as to both counts. Count 1 as to first degree murder or second degree murder.
No objection.
No objection.
3.3A, aggravation of a felony by carrying a firearm. This is as to lesser manslaughter as to each count.
No objection.
No objection.
Let me see the indictment for a second. Then, for the clerk, Mr. Carriante. Okay. We'll keep going while he gets that form. I want to check one thing. 3.6A, insanity.
No objection.
No objection.
Now, let's point out there, you removed one paragraph that was included in an earlier version as not applicable. That had to do with any prior judicial determinations about insanity, and that you accept that as being appropriate, correct?
Yes, sir.
Yes, sir.
Okay. 3.6D, voluntary intoxication.
No objection.
No objection.
3.7, plea of not guilty, reasonable doubt, burden of proof.
No objection.
3.9, weighing the evidence. You've reduced that to 8 factors and corrected that portion dealing with the defendant testifying.
No objection.
No objection.
3.9A, defendant not testifying.
No objection.
No objection.
3.9B, defendant statements.
No objection.
No objection.
3.10, rules for deliberation.
No objection.
No objection.
3.11, cautionary instruction.
No
No
objection.
objection.
3.12, verdict, the introductory language.
No objection.
No objection.
The verdict form itself, which I will read to the jury in its entirety.
No objection.
No objection, Your Honor.
Mm-hmm. 312A, single defendant, multiple counts or informations.
No objection.
No objections are accepted.
313, submitting case to jury in the most recent version.
No objection.
No objections.
Let's take 1 second.
Double print that real quick.
Yeah, council, one of the things that sent back as well is a copy of the indictment in pertinent portion. Let's look at that. Yeah, let me see. Now, in such cases, it's very common to, for lack of a better term, use a dummy indictment, that is, to remove certain information on the second page. Specifically, where it says indictment for murder in the first degree premeditated, listing it as a capital felony. Can we agree on any modification there?
Yes, sir.
Okay. How do you wish to do that? Just have that entire section whited out?
I'm fine with that.
Yes.
Okay. All right. With the assistance of the clerk, we're going to do that. Present that to me before we start tomorrow so we can go over it and make sure everybody's got a copy and that we're all in agreement, okay?
Yes, sir.
All right. Other matters on our instructions and the indictment that we send back.
Yes, sir.
All right.
Just, you were talking about whiting out this whole thing, or just the part where it says the Florida statute number and then right underneath?
I was thinking, quite frankly, since what counts is the substantive in count two, you'd white out the whole thing.
Pretty much, yeah, you're now.